I just have a few, and let me just say for the record, I'd go into any court with my friend from North Carolina. I know I'd be very well represented. I'd be happy to have him look over any agreement I was signing. But I have a couple of questions for my friend. Mr. Bishop, you mentioned in your testimony the fact that courts can invalidate unlawful arbitration agreements. Can you explain a bit more detail how they're capable of doing this?
I think the gentleman, and arbitration agreements are like any other contract. Contracts require one party to make an offer, the other party to give an acceptance, to exchange consideration between two competent parties. They have to be competent, capable of dealing for their own business. They can be invalidated by common contract defenses. So if someone, I beg your pardon, thank you. If someone engages in fraud, if there's duress, if the contract is unconscionable, all these legal standards that apply, and if it's an unenforceable contract at law, it'll be not enforceable. So a party being tricked into a contract, that contract's not valid. If a party is threatened or coerced, the contract's not valid, including any arbitration provision there is in there. Courts can and do step in and invalidate arbitration agreements when these defenses apply. If an arbitration agreement were truly forced and one party was actually required to agree to it, a court could step in and invalidate the agreement under all usual contract defenses.
Let me also ask you, can you speak, and you touched on this a little bit in your testimony, the benefits of arbitration for consumers?
You know, it's interesting. The chairman used the example of someone buying or being a cell phone or buying a telephone for a cell phone contract, and that if there's an arbitration agreement or clause in the consumer agreement, that they'd then be bound by that, and they may not read that. And I don't necessarily disagree with the chairman that there are certain contracts that people won't read. There's a reason they won't read them. To most cell phone customers, whether they're going to arbitrate or litigate some dispute in the future is probably not a big deal. And in fact, the one case that comes to mind is the Supreme Court's decision in AT&T Mobility versus Concepcion, a case in 2011. And what that was about was consumers had gotten a free phone, but the dispute was they had been surprised by the fact they had to pay the sales tax on the phone. So it was $5 or something. And that's true. If the arbitration agreement or clause in that agreement were rendered unenforceable, I don't think that consumer's going to court over the $5. The difference that it makes is the class action trial lawyer that wants to accumulate tens of thousands of those consumers in order to bring a multi-million-dollar claim against AT&T over that issue, and then pocket millions of dollars in fees, and the consumer then gets a coupon for $5. And in order to get that coupon, the consumer has to make sure he fills out the forms and submits them all to the court. And the stats are that, as a practical matter, about 4% of people in big class actions do that. So when you say it's a choice between, for goodness sake, the jury trial right under the Constitution, or being forced into some unfair process, that's a false choice. That's not what's happening.
And Mr. Bishop, how long does it typically take to go through arbitration as compared to litigation?
Depends on the type of the dispute, but there's some concrete numbers. People have studied that in considerable detail. And two categories that are covered by the bill include consumer disputes and employment disputes. In consumer disputes, on average, arbitration took 321 days, while litigation took 439 days. So litigation took about 4 months longer. Employment disputes, on average, arbitration took 659 days, while litigation took 715 days, or about 2 months longer. And I can tell you that from long experience that in either event, it's rare, very rare, about 1 or 2% of cases actually are presented to a jury ultimately. Almost all litigation in court ends in a settlement after some lengthy procedure and the lawyer's fees that come along with it. So it's not really the case. Again, it's a false choice to say that it's between an arbitration way of settling or going to a jury. That's not the way it typically plays out.
And what does that lengthier timeline mean for consumers, especially those with limited financial means and limited time availability?
Well, so particularly consider the example of the cell phone customer with the $5 dispute. He's he or she is just not going to go to court. Even if it's considerably more than that, they're probably not going to be able to afford lawyers. If they do, consider the fact that arbitration, the Federal Arbitration Act was passed in 1925. Arbitration's been the rule for 100 years for people who choose it in their contracts almost. You take that away, you're going to dump into the existing federal and state court systems an avalanche of additional litigation, which is going to make them all the more backlogged or consume additional resources in order to have disputes passed through. So consumers would have to not only be able to afford a lawyer, but they're going to have longer times to wait for cases to be resolved in court.
And while the bill's entitled the, quote, Forced Arbitration and Justice Repeal Act, doesn't really eliminate, as my friends acknowledged, all arbitration because union contracts are left untouched. What sort of imbalance would this strike between union and non-union employees?
It's a huge imbalance. The Democrats' carve-out for their union friends is just plain wrong. If you're a union, you get to take advantage of all the benefits that arbitration has to offer. You're going to spend less, probably recover more. You're going to resolve the dispute more quickly. You may well have a better chance of winning than if you went to court. All of the benefits we've discussed today attendant to arbitration, unions get them, but not the rest of Americans.
Well, and we're talking about what the relative benefits of this process are. Who benefits more from repeal, the employees themselves or class action attorneys who quite often walk away with the lion's share of the settlement?
Well, that's absolutely it. The lawyers, particularly, and you know, I said as I began that I've been practicing law, litigating cases for an entire career, but I represented people who needed lawyers, and sometimes plaintiffs, sometimes defendant, serving people as effectively, as cost-effectively as possible. But there are a whole lot of lawyers out there in the plaintiff's class action bar that have something far different in mind. Class settlements, as I said, are great for lawyers. They get a huge payday, and they're typically a disappointment for class members who might get a small payment, may get a coupon, as I indicated, that has little value. Expensive lawsuits will drive up the cost of consumer goods. Consider if every contract for cell phone service, you pay $70 or $80 a month for your cell phone service, if the company has to factor in the cost of hundreds of thousands of dollars of litigation expenses to fend off constant class action litigation, where will that cost be absorbed? It'll be absorbed into the cost of the service. So that's on top of exorbitant prices Americans are already struggling with in this terribly inflationary environment. So plaintiffs' lawyers will benefit, plainly, and they'll do so at the expense of hardworking Americans.
Thank you very much. Thank you, Mr. Chairman. Yield back.
Dr. Burgess.
Thank you, Mr. Chairman. Actually, Ranking Member Cole covered most of the ground that I would have asked my friend from North Carolina about. But just to this last point that was just articulated, under current law, as a practical matter right now, can someone be forced? Is there such a thing as forced arbitration?
There's not. The chairman of the subcommittee was describing what would be in the contract, and he said it would say you're going to be forced to go to arbitration. I can tell you I've looked at arbitration clauses for a long time. None of them say that. There's an agreement to arbitrate. And they make the agreement to arbitrate at the front end. And so that's when the agreement is made. Once the dispute arises, the agreement's enforced. If someone says, well, I don't want to arbitrate at that point, and so they go sue in violation of the agreement that they made, then the court will enforce the arbitration agreement and send the party to arbitration.
And if the results, as far as the party is concerned, are not satisfactory, do they still have the recourse of filing a lawsuit?
They do not as a general proposition, but in certain circumstances they do. If there's a manifest disregard by the law, of the law by the arbitrators that appears in an award, then they can. There are limited grounds on which an appeal is possible. But as a general proposition, the idea is you're going to a place that is faster, doesn't have as many involved rules. You're not going to have discovery and depositions and document requests that go on forever. You're going to be able to pick the time, schedule the time you want to have it resolved instead of whenever it comes up on the court calendar and show up 3 or 4 times till you happen to be called. There are a number of things that are advantageous about arbitration, and if you choose that in your agreement, that's what the nature of contracts is. You make your bargain, and then the bargain is enforced.
I do just have to make a comment about, we've heard a lot about how difficult it is to read the disclaimers in contracts when you sign up for a cell phone or buy a car. But I can't help but feel that a lot of the very verbose and lugubrious language that is in those contracts is a result of things that actually started here. And I don't know if anyone had the experience of buying a house in 2005 and then buying a house in 2017. But I will tell you, having been through that process, it's a lot harder to buy a house today from your community bank because of regulations and requirements and restrictions that Congress passed in the Dodd-Frank Act. And we made this process significantly more onerous. In many cases, I could fail to see where the consumer protection even existed. It was just more language that someone had to pick through and try to understand. So while the corporations may be guilty of several things, I think Congress has to bear some of the responsibility of why these contracts are so onerous and ponderous. But thank you, Mr. Chairman, and I yield back.
Thank you.
And Mr. Bishop, you and I have very similar careers, although you've got 5 more years of being a lawyer than me. I did 25 years primarily representing defendants, banks, credit unions, insurance companies, but plaintiff work every now and then, but generally not.
I did more plaintiff work than you.
Okay, well then you and I were sort of on the opposite sides, and we're on the opposite sides of this issue. Mm-hmm. Because in my opinion, in those cases, in those situations, the company, the business, and primarily the big businesses where there is fear by them that there may be a class action because they have so many customers or they have so many employees that any one person can't take on Apple. Any one person can't take on Facebook. Any one person generally can't take on Comcast. Not to say any of them do anything wrong, but from time to time they make mistakes. You would know that as a lawyer. I know that as a lawyer. So the purpose of this is to allow those individuals to voluntarily either seek the court system pursuant to the 7th Amendment and sort of the approach that we take here in America or not. And I think, sir, and I'll give you a chance to answer this, I think if we were a tribunal, you proved Mr. Johnson's case. And the reason I think that is you said that if we didn't have this, there would be an avalanche. I think that was your terminology, an avalanche of cases that would go to the courts. Because most people would say, I want somebody who I know is impartial to handle this matter for me. And quite frankly, I believe in the system. You and I have had probably much the same experience. It's been positive. It's been fair. It's been honest. And that's why, as a lawyer or as a party in a case, I trust those courts. I'll let you respond to that. And then I want to talk to you about unions for 1 second.
Thank you for the opportunity to respond. And I think we might have a different view about the utility, particularly of class action litigation, and what the proportional benefits are to the class counsel versus the claimants, the members of the class on the whole. But even if you take that aside, and the example that the chairman and you and others have cited repeatedly of consumers in cell phone contracts, telecom or cable contracts, all the like. The problem with this bill is that it's a shotgun approach rather than a rifle shot. It doesn't just attend to that issue. It not only does it render unenforceable the arbitration agreement in the case that I talked about, Benish versus North Carolina Dance Theater, with an impecunious, barely thriving, small, very small employer, a new professional arts company that's starting up. I'm so glad that it survived. Members of the North Carolina League of Cities probably are appreciative that that arts community survived all those years ago because of an arbitration provision. But I can give you another example. I've had another case in which I litigated over the validity and enforceability of an arbitration clause in a partnership agreement. So the partnership agreement not only set all the details of how these partners are going to relate to each other for the conduct of their business, it also had employment provisions.
But in
because this
something
bill is so
like that,
broad,
though, let me reclaim my time for a second, and I appreciate your answers. But something like that, there is equal footing, more equal footing certainly than, say, I have with Apple, or he has with Facebook, or she has with Comcast.
right? But the bill outlaws that.
Well, I'm not sure I agree with you, because it talks about employment problems, antitrust problems, consumer problems, and I can't remember what was the fourth thing.
Antitrust.
Antitrust. So antitrust, like, one of the things we've been talking about, and not we, but the Judiciary Committee has been talking about, is the fact that some of those platforms are so big that if you start working with them, all of a sudden you potentially lose your product. So we're trying to level the playing field on a voluntary basis. We want to talk about freedom on a voluntary basis between the really big guys and those that are much smaller. So I'll end with this, because you questioned the union section of this, the collective bargaining section. And there, I think, again, it's between two co-equals there, the employer and the union. It isn't between the employer and Mrs. McGillicuddy, who, doesn't have nearly the bargaining power that the union would have vis-a-vis the employer. And it says, though, for the individuals, that there is, for the individual worker, they can seek judicial enforcement of any right arising under the Constitution, state constitution, or any federal or state statute or public policy. So they can still bring a claim, but between the union and the business, they're of equal bargaining power, and they have made a contract. And in the old days, back when you and I were practicing, sometimes they called these adhesion contracts, where there is no equal bargaining between, the big company and the individual. So I'll let you respond to that, and then I'll yield back to the chair.
I thank you for that opportunity as well. It's interesting to me that the only situation that is picked out in the statute, in the bill, in situations where there is
You guys got to
equal
watch that
bargaining
table.
power.
You'll end up
Yeah,
with the
yeah,
water in your lap.
That was the subcommittee chairman, not me. The only situation you pick out is the union situation, where you believe there'd be relatively equal bargaining power. If you have an employee who is really highly compensated sales employee, earns $750,000 a year, enters into a contract, a commission agreement with an employer, maybe an employer in a textile business, very hard pressed, barely making ends meet. They end up in a dispute with an arbitration provision under this bill. That employer can't make sure that goes to arbitration. They've got to litigate it out. That's my point. Mr. Johnson made reference to the fact that H.R. 4445 passed a couple of months ago. I'm not sure how long ago now. The Gretchen Carlson situation is signed into law by the president. It was a shock. It was a rifle approach to exempting sexual harassment, sexual assault cases from the effect of binding arbitration. I can understand that. In fact, I voted for it. Most Republicans did. This is different. This is a scattershot, blunderbuss shotgun approach that kills arbitration in situations where it certainly should occur if parties have agreed to it, including
All right,
many
I'm going to reclaim my time. You've done a good job in responding to my concerns.